Norman Bissett. Hello, Pak Norman.
Hey, Mo, how's it going?
How are you today?
Not bad. A little bit older than that photograph.
Oh, really? Yeah. But looks like getting wiser, yeah?
Probably not.
Mr. Norman is the foreign legal consultant at HHP law firm. HHP is Hadiputranto, Hadinoto, and partners. Are you in Jakarta now, Pak Norman?
I'm in Jakarta now, correct.
Oh, in Jakarta. Okay, thank you very much for your time this afternoon. And as always, our moderator is Bapak Hendra Sinadia, Executive Director of Indonesian Coal Mining Association. Hello, Pak Hendra.
Hello, Bu Desi.
Hello, thank you very much for your support to our event on our webinar series. So before we start, I would like to inform you to all the participants that the recorded version of this webinar will be available after finish. So the recording version of this webinar will be available after finish. And the second one, all the material of presentations can be downloaded at the chat column. So you can see our chat column. There's a link of the material presentation, so you can download the material there. So we don't send you any email. You can directly download from the chat column. And the third one, if you have any questions, just write on the Q&A tool on your laptop or your handphone. So you can find the Q&A tool on the screen. Just write your questions there, or just click raise hand for direct question to our speaker. And after that, our host will assist you to activate your microphone. So there's two options. You can click Q&A tool or just click raise hand. We would like to invite all the participants to optimize the Q&A tools. You can introduce yourself and make networking with other participants. Okay, without any further ado, Pak Hendra, time is yours.
Okay, thank you, Bu Desi. Thank you for all the participants. Thank you for the speakers, my friends, Pak Bill Sullivan, Pak Norman Bissett, Pak Hadinoto, the host from Petromindo and CoalAsia. Thank you for inviting me to moderate this that will be very interesting discussions today. The second webinar of the understanding of the new mining law and implication to the industry, hosted by Petromindo and CoalAsia. In the first series of webinar, we had interesting discussions delivered by two ladies presenters, Bu Arifidea and Bu Eva. And today we have Pak Bill and Pak Norman. Before I give the space, not floors, to Pak Bill and Pak Norman, I'd like to give a little bit opening remarks of what will be the topic of today. Okay, as we know that we expect the government to promulgate or enact the new mining law, the amendment of the law number 4/2009 by today, or 30 days after the parliament has passed the new mining bill on the 12th of May 2020. So hopefully by today we're gonna have the new law with the law number something that will be effective by the date of the issuance. And the arrival of the mining bill, as we know, has created some controversies in the public. Some people criticize the law. As always, yeah, mining bill is a very, very controversial for some, yeah, in many countries, not only Indonesia, and even some elements in the civil society organizations would like to file this new law to the Supreme Court. But on the other hand, the industry, especially mining associations, they applauded the arrival of the new mining law, as they believe that the new mining law provides certainty and legal certainty and business certainty for the miners. Yeah, and then the associations appreciate the government for the passing of the new mining law. Despite positive aspect or sentiment from the investor, from the miners, the question remains, is it the new mining law, will it be interesting or attractive for the investors? Those will be the main issue or the key discussion of our webinar today. And if you look at the Fraser Institute survey of mine, the annual survey, Indonesia is ranked on the top 10 of the mining geological perspective index, among the best geological index in the world. But on the other hand, in the policy perspective index, we are rated among the lowest in the countries and also regions in the world. It has been, the position has been there for maybe 2 decades or more, yeah, after late 90s. And then one of the key assessment of the survey at the time, that the legal and regulatory framework of Indonesia doesn't support the greenfield investment or the mining, big scale mining investment. So the new mining law will have a very important role in attracting the investors. If we're talking about investors, of course, I view the investor, there are 2 types of investors. The existing investor, those who are holding the permit, IUP or IUGP, yeah, the mining services permit, or foreign investors who hold some shares in the IUP and also in the CCOW or COW, or the prospective investor. Prospective investor means that those who are keen to invest in Indonesia, because Indonesia, in terms of geological perspective, is still attractive, but they are waiting for the new mining law or to give the certainty. So what Pak Bill Sullivan and Pak Norman present today, we're gonna see the view whether this new law is attractive or not. And the other thing that I'd like to touch before I give the space to the presenters is talking about the timing. The timing is very, very critical in this matter. If we look at the issuance of the mining law number 4, 2009, at the time it was during the booming era of community, yeah? From 2008, 2011, China has at the time had experienced double-digit growth, and it triggered the rise of the community markets and booming everywhere, yeah, in mining, especially in Indonesia. Yet, very few investors, foreign investors, came to Indonesia despite the booming era, yeah. And on the other hand, the rise of nationalism in many countries on the world was on the rise during that time, and even the sentiment of resource nationalism is also very high at the time, and that's why we have seen, yeah, the foreign investor, they're beginning to gradually withdraw, yeah, from the Indonesian market through the acquisition or through the M&A and something. Yeah? And only few foreign investor, big investor, and now hold the majority investment in the, even in the COW or the IUP. On the other hand, the timing for the new mining law is very different. Now the new mining law was to be enacted in the time of pandemic COVID-19. Some people said this will be the worst recessions that we experienced since the Great Depressions. So the timing is very different now, yeah. So I mentioned earlier that when the law number 4 was issued, it was during the boom time. Yet the investor, foreign investor, only very few, no major greenfield discovery during the last decade. So it's very challenging now for the government and the lawmakers to justify that the issuance of the mining law will increase the appetite of the investor to invest in Indonesia. So this is a very difficult situation now, and we can look at the pandemic COVID-19 also triggers the geopolitical changes across the world. The trade tension between the US and China is keep increasing. The geopolitical tension also affecting Hong Kong, Hong Kong status. As we know, the Hong Kong is one of the important source for foreign investment funding to Indonesia. So what will be the impact of the mining law to the foreign investor, given the situation in Hong Kong, China trade relation amid the pandemic COVID-19? So those are the background of the situations and the arrival of the new mining law. And last but not least, we have to look at the implementing regulation, the PP. Devils is in the details. And the government has promised that they will issue the draft of PP very soon, within 6 months to be discussed by the stakeholders. So those are my brief opening remarks. Then without further ado, I'd like to give space, floor, to Mr. Bill Sullivan to present your topic. Thank you.
Thank you, Sinadia, for that introduction. It's always a pleasure for me to speak at Petromindo events, whether they be physical or through webinars. The topic today, I think, is a very interesting one and really forces us to delve into just how the changes introduced by the new mining law are going to work in practice.
Bill, can you make it full screen?
Full screen?
Just click the one below, full screen.
Full screen, just a second. Full screen. Mm-hmm. Oh, not that one.
Oh.
Is that how we're doing there? Ah.
Okay, right. Thank you.
Good. So as Sinadia has explained, we do have a new mining law. We're currently waiting for the President's signature and for promulgation by the Ministry of Law and Human Rights. One of the most interesting things about the new mining law is that it now deals with a host of matters that were previously only dealt with in the implementing regulations. And that, I think, is a positive thing, because one of the complaints that has always been made about the 2009 mining law is that you have a very general law followed by many, many implementing regulations. As we'll see, however, the new mining law also has its weaknesses in that regard. Net, though, I'm quietly positive about the new mining law. And I think investors generally, including foreign investors, on balance, will view the new mining law as good news. That's probably a surprising thing for you to hear me say, because I'm not generally a great supporter of the mining laws and regulations of Indonesia, but I think this time the DPR may be on the right track. Perhaps not for the reasons that many people think, but I'm going to bring to your attention a couple of reasons that you perhaps have not thought of as to why the new mining law is good news. That said, there are unquestionably many uncertainties remaining as to how key provisions of the new mining law will be interpreted, and until we have the implementing regulations, it's impossible to reach a definitive conclusion on many provisions in the new mining law. In terms of good news, it must be a positive, I would suggest, for all investors, that the process of eliminating the authority of the provincial governments to issue IUPs and generally scaling back the role of provincial and regional governments in regulating and controlling the mining space has now been fundamentally completed by the new mining law. We don't need to dwell on all the horror stories that investors, foreign and domestic, have relayed in the past about their experiences of dealing with the provincial and regional governments. But I think it's fair to say they have not been happy stories, and anything that eliminates the residual authority of the provincial and regional governments to issue mining licenses must be a good thing. So we now have the central government with exclusive authority to issue business licenses for mining, and it appears that the issuance of business licenses for mining is going to be integrated with the OSS system of general business licensing for companies and businesses in Indonesia. Again, that seems to me to be a positive thing, although it has various problems. The OSS system, I think, is a positive development, and the idea of integrating mining licenses with the OSS system on its face and subject to the detail is probably a good idea. In addition, we see the new mining law giving the central government greater authority with regard to such things as supervising mining activities and determining mining business areas and mining business license areas. Part and parcel of having a central government firmly in control of the mining sector from a regulatory and administrative perspective. And so I would say that's a very positive aspect of the new mining law, even if it's only the culmination of a process that's been ongoing for some years now. We come now to the extension of the contracts of work and the coal contracts of work. And let's not kid ourselves. This was the real focus of everyone's efforts in getting the new mining law through the DPR. And this is unquestionably the most significant change that the new mining law makes. No one should doubt that for a moment. Although the new mining law purports to give COW holders and CCOW holders the same rights to obtain so-called continuation IUPKs, we must be very clear here that the contract of work holders had really sorted out their problems a couple of years ago in terms of the conclusion of the contract of work renegotiations, and they were already assured of 2 extensions of 10 years each. So although the new mining law is dressed up to make it look as though the new mining law is doing good things for both COW holders and CCOW holders, the reality is that it's really the major coal producers who benefit from the new mining law. Why? Because prior to the new mining law, they didn't have any clear right to continue to operate their mining concessions after their contracts of work expired. So the new mining law now ably addresses that by providing that coal contract of work holders are able to obtain so-called continuation IUPKs. There will be with 2 extensions of 10 years each. They don't have to go through an auction. They get them after the expiration of their CCOWs, but taking into account the need to increase state revenue. The new mining law also makes clear that applications for continuation IUPKs must be submitted not earlier than 5 years before the expiry of the relevant coal contract of work and not later than 1 year. this concept of increase in state revenue is an interesting one, and I think this is intended to reflect the quid pro quo that the government expects in return for resolving the legal certainty problems of the coal contract of work holders. This increase in state revenue is to be achieved through one or other of readjusting tax arrangements, granting mining business license areas in accordance with the plan of development of the existing contract areas of coal contract of work holders as approved by the Minister of Energy and Mineral Resources, and by imposing a new obligation on coal producers to increase the added value of coal. That obligation has actually always been there, but although it was in the 2009 mining law, previously coal producers got a free pass, and it was only metal minerals producers who were really obliged to carry out local value-added activity. I think the intention is palatably clear here, and that is to allow coal contract of work holders to obtain WIUPKs, that is mining business license areas, covering 100% of their former contract areas. Now, the DPR has introduced a lot of window dressing here to make it appear as though it's not a lay down misere, and that there are issues to be considered in terms of the size of WIUPKs granted to former CCOW holders. But I don't think we really should be deceived by this. I would be amazed to see any coal contract of work holder who didn't get a continuation IUPK and who didn't get a WIUPK that was substantially 100% of the prospective and productive area of its former coal contract area. And I don't think anyone realistically thinks otherwise. If you doubt that, you just have to focus on the fact that the new mining law has removed the previous 15,000 hectare cap on WIUPKs for coal. Why has that been done? Well, that's been done to eliminate the legal basis for any claim by state-owned enterprises that they had a priority right over former coal contract of work areas in excess of 15,000 hectares. This was something that the former Minister of State-Owned Enterprises pushed very aggressively, and it has now been rendered moot by removing this cap. So why is this good news? This is good news because it means that SOE domination of the coal industry has been avoided. Yes, major coal producers have been treated extraordinarily handsomely by the DPR. But what was the alternative? The alternative would have been vastly worse for the coal sector, for the private sector as a whole. We would have seen the private sector marginalized. We would have seen state-owned enterprises totally dominating the coal industry. What would that have meant for foreign investors, particularly foreign goods and services providers to the coal industry? The outlook would have been very bleak indeed. So those people who say, hey, this is unfair, coal contract of work holders have got a Rolls-Royce run here, are really overlooking what the alternative was. And so while I can understand the concern of NGOs and other social activist groups that there is some unfairness associated with the special treatment that has been accorded to the major coal producers, hey, the alternative would have been so much worse, and no one should lose sight of that. The next major aspect of the new mining law is the introduction of a very intriguing concept in the context of domestic processing and refining. And that is the idea that if companies carry out integrated mining and processing, refining activity, or integrated coal getting and domestic use and utilization of coal, they will get an initial license term of 30 years as opposed to the existing arrangement of 20 years plus additional 10-year license extensions. Now, there are many unclear things here, but the intention is probably to allow integrated mining companies to have what are called life of mine operating rights. It was actually a little clearer in the now on hold omnibus bill, but the intention would seem to be that if you carry out integrated mining activities, then you will be able to get successive 10-year extensions until the end of the commercial life of your mine. Again, what does integrated mean? That's not entirely clear either, but based on what we have heard and been able to ascertain, integrated probably means that the same company must carry out both activities. That is, that the mining license holder must also carry out the coal utilization and or the metal mineral processing and refining. Now, is this a good thing or a bad thing? Well, look, it depends on your point of view. The implication is that if you integrate both aspects of production and processing and refining into the one company, then in the case of PMA companies, that means that they will be exposed to the divestiture obligation in respect of their processing and refining activities, as well as in respect of their mining activities. As listeners will no doubt be aware, the current practice is to separate the mining and the processing and refining to avoid the divestiture obligation in respect of processing and refining. I have no doubt that the next speaker, Norman Bissett, will say more about how the divestiture obligation may impact PMA mining companies undertaking integrated operations. But suffice it to say that there's obviously a trade-off here in the case of PMA mining companies by, on the one hand, getting a life of mine operating right, which might be considered to be very attractive, but at the cost probably of an expanded divestiture obligation. And this is a cost-benefit analysis that every PMA mining company will have to undertake. There is also good news in the domestic and processing and refining provisions of the new mining law, to the extent that it now appears that there's going to be greater flexibility in setting the minimum requirements for domestic processing and refining. These minimum requirements are now going to take into account the achievable economic value added in the case of individual minerals, and also take into account market needs for the resulting product. In other jurisdictions, in other countries, taking into account these factors would not seem particularly remarkable. But I would suggest that in Indonesia's case, with its previous one-size-fits-all approach to domestic processing and refining, this introduction of a measure of flexibility and a focus on what the market actually needs in terms of value-added products is a huge advance in terms of the government's thinking, and a growing maturity, I would suggest, on the government's part in terms of how it approaches the whole concept of domestic processing and refining. A very positive thing. Also, the new mining law indicates that the government is going to more closely regulate domestic pricing and trading systems for metal minerals supplied locally to refineries and smelters in order to protect mineral suppliers with limited alternative markets. Again, I think this is a very positive aspect of the new mining law, because it reflects, I think, a greater concentration on fairness, a greater concentration on ensuring that domestic processing and refining does not only benefit certain parties, but in fact, all parties have to be fairly treated in terms of the sale of metal minerals to local refineries and smelters. So that, I think, will go a long way to addressing, if it's done properly, much of the opposition amongst some local mineral producers, particularly nickel ore producers and bauxite ore producers, to how the domestic processing and refining obligation has been applied to date. The third thing that I wanted to talk about to date was, what does the new mining law mean for the continued export of metal ores and Indonesia's on again, off again export ban, which has gone through so many variations that I've just lost count, really, of how many times it's been extended and varied. And I defy anyone on the call to say how many times this obligation has been changed. Intriguingly, the new mining law says that metal ore exports will be allowed for 3 more years, while at the same time saying that the government may expressly prohibit exports of certain metal ores by regulation. Now, is this a significant change, or are we trying to read too much into what the new mining law says here? We'll have to wait, I think, until we see the regulation that is promised. To me, what's unclear is, are we talking about greater flexibility regarding metal mineral exports because the government wants to protect nickel and bauxite producers specifically, or is it a recognition that the current refinery smelter construction deadline of 2022 is unrealistic and not going to be achieved? Or is it perhaps picking up on Hendra's earlier point at the introduction, a recognition of the terribly serious economic and fiscal crises that Indonesia is suffering at the moment, and the need for the government to rethink what the #1 priority should be? That is the government saying here, hey, in a time like this, we have to be flexible and prioritize increasing export revenues and fiscal security over things such as domestic processing and refining. All intriguing possibilities. We will, however, have to wait and see what the government does by regulation here. The next thing I wanted to briefly mention was exploration. Certainly belatedly, the government is trying to do something about overcoming the very empty pipeline of new mining projects in Indonesia and the lack of any serious exploration activity aimed at increasing Indonesia's proven reserves over the last few years. Now mining companies are going to be obliged to commit to exploration activity every year, and they're going to be obliged to commit a certain budget to exploration activity every year, which budget must be approved by the Ministry of Energy and Mineral Resources. Now, any endeavor to increase exploration activity has to be a good thing. As Hendra alluded to in his opening remarks, the exploration industry has died in Indonesia. 10 years ago, there were perhaps 100 exploration companies active in Indonesia. Today, you could list the number of active exploration companies on the fingers of one hand and still have several fingers left over. So the exploration situation is dire. Something must be done about it. Is this sufficient? I have my doubts, but at least the government is now prioritizing exploration activity and trying to ensure that there is more exploration activity going forward than there has been in the past, which is also a positive thing. Other changes, look, there are any number of other changes introduced by the new mining law. Two that I noted in particular were, though, that existing holders of mining licenses have 2 years to comply with the business licensing provisions of the new mining law. This, I think, indicates that there's going to be a long lead-in time for many aspects of the new mining law, and the transitional provisions also provide for local governments to turn over to the central government all the license documentation that they hold and which was previously in their authority, again, not later than 2 years after the new mining law becomes effective. A necessary part of the process of curtailing the role of local governments in the licensing process and giving the central government everything it needs to be the one-stop shop for the licensing of mining projects. So look, let me wrap up here and turn it over to Norman. A number of things I can conclude. It would be naive to imagine that anyone other than coal contract of work holders are the big winners from the new mining law. Equally, it would be naive to imagine that anyone other than state-owned enterprises are the big losers. But the private sector will benefit, regardless of who the big winners and the big losers are, by ensuring that there is no SOE domination of the coal mining industry going forward. It must be a positive that the government apparently intends to be more flexible about how the domestic processing and refining obligations are implemented going forward. There is now, however, I think, some residual concern about the government's commitment to continued smelter construction, and of course, much uncertainty remains until the implementing regulations are issued. The mining law actually says they'll be issued within 12 months, but who's to know whether that deadline will actually be met or not? There is no penalty for not issuing the implementing regulations within 12 months. And if past experience is any guide, I'd be betting it'll be well after 12 months. Foreign investors and foreign goods and services providers should benefit from the rollback of regional autonomy in mining business licensing. They'll certainly benefit from no state-owned enterprise domination of the coal industry, and they may well benefit from the greater flexibility regarding domestic processing and refining. So yes, I would say you're right. Coal contract of work holders have been extraordinarily favoured by the government, but the SOE alternative would have been so much worse. I think what's most interesting here is that the ongoing economic and fiscal crises Indonesia is facing may have forced the government to rethink its priorities. The new mining law is indeed, I would suggest, a very good example of the old saying that difficult economic times produce better government policies than in robust economic times. And I think that's the difference, Sinadia, between the environment in which the 2009 mining law was introduced, a time of very robust economic times, when we got very bad policy, and the current COVID-19 situation where we're in very difficult economic times and we've now got a much better policy in terms of the new mining law. Thank you very much. Let me stop there.
Thank you, Mr. Bill Sullivan, for the presentations. Very interesting, Pak Bill. Your last phrase about the timing, yeah, you mentioned about the good timing, yeah, and the bad timing. Sometimes the hard times produce good policy, yeah? And hopefully this in time of crisis, the mining law was just passed will be better for the industry, not only for the existing investor, but hopefully for the prospective investors. Indonesian has been known for its resiliency, so yeah, hopefully this our resiliency exemplified in the drafting of the new mining bill. Okay.
Hendra, just on that point, I think it's useful to remember that Muhammad Sadli, President Sukarno's favorite economist, was very fond of saying, you should never miss a good economic crisis and the opportunities it presents for policy reform.
I see. I remember the law number 167 at the time, the opening up of Indonesia economy after the old regime, to the
I think Muhammad Sadli nailed in that regard.
You're right. Okay, thank you, Pak Bill Sullivan. Without further ado, I'd like to pass over to Pak Norman Bissett, foreign legal consultant from Hadinoto, Hadiputranto and Partners. Mr. Bissett will explore the divestment obligation under the new mining law. Okay, Pak Norman Bissett.
Do we, I think somebody's going to put the slides on screen. Great. Right, there we are. Just before we start. So, first of all, many thanks to you, Pat Hendra. Many thanks to Bill. That was very informative. And many thanks to Petromindo for inviting Harpe to speak at this session this afternoon. I immediately said yes when Petromindo asked me to speak about what was changing under the new mining law in respect of divestment. And it wasn't until I was drafting these slides late last night that I realized I'd been given quite a difficult task to do. Because I think the main message that will come from what I'm going to say is actually the new mining law doesn't really change divestment very much, if at all. There are one or two changes, and some of them may be potentially important, but apart from that, it's not much of a big story. But let's explore that in a bit more detail. So can we go on to the next slide, please? So let's remind ourselves basically what the old mining law said, the 2009 mining law. Basically, it said holders of IUPs, IPKs, where shares are owned by foreign investors must begin divesting after 5 years of production. And it's important to realize that the mining law, the old mining law and the new mining law talks about IUP, IPK companies whose shares are held by foreign investors. Under Government Regulation 23, what it talks about is companies whose shares are held by foreign investors in the context of foreign investment. So the distinction between GR23, which talks about PMA companies, and the mining law, which talks about companies that are owned by foreign investors. And that's relevant where people begin to look at listed company structures, et cetera, whereas we all know you can begin to create listed companies that even though they have foreign investors are PTBSs. Under the mining law, they would still be caught by these divestment requirements. Under the GR, they're not caught by the divestment requirements. So again, picking up on one of the points that Pat Bill said, we have to wait to see what the new government regulations and implementing regulations do to see whether that point is picked up going forward. Again, under the mining law, who are the Indonesian participants? It's under the old mining law, it was governments, regional governments, BMNs, BMDs, with the offer to be made within 90 days of the termination, the completion of the 50th year of production. Interestingly too, under the old mining law never actually set out what the foreign shareholding, what the maximum foreign shareholding requirement ought to be. That was a requirement that was introduced by GR23, but we had this discussion a number of times in the context of recent divestment processes with DG Mining, that actually it was those guys who were writing the rules as to what the divestment requirement was. Can we go on to the next slide, please? So again, yes, perfect. So again, what's the divestment requirement? It's pretty straightforward. By year 6, you've got to divest 20% of the shares of the company so that they're held by Indonesian participants. By year 7, you divest another 10%, so the IP, the Indonesian participant gets 30%. By year 8, 37, by year 9, 44, by year 10, the Indonesian participant acquires a majority shareholding. Next slide, please. And again, this slide is a little bit detailed, but basically the offer process under the old mining law, the old GR, still the current GR, was you offer to the government's got 90 days to consider your offer, it's got 30 days to respond to your offer. If the government says no, then within 7 days you offer to provincial, regional, or city government. So government gets top priority, then provincial, regional, city are all treated equally, they get next priority. If they say no after 30 days of evaluation, then within 7 days, you offer to BUMN and BUMD. And again, BUMN and BUMD have equal priority. It's not that the BUMD get priority over the BMN or vice versa. They get equal priority. If they say no, then you offer to the to national companies. We'll look at the next slide. Just one point to make about the offer to the government. What we have seen in a number of instances is the offer is made to the government, and the government exercises that first priority right, but then the government will nominate an Indonesian SOE to pick up or to take over the shareholding. So even though the SOEs come below the provincial regional governments, what we're seeing in practice is the government is saying, yes, I'm going to take up that divestment right, but I'm not going to hold the shares directly. I nominate Inalum Mind ID to become the government's shareholder. Slide 7, please, page 7. If the BMN BMD both say no or equally say no within 30, after the 30-day review, then within 7 days you offer to national companies. If national companies say no, then you can try and list shares in the stock market to satisfy those divestment requirements. So that's basically a very straightforward process. Next slide, please. Some other rules to remember as we still talk about divestment under the old regime. And again, to pick up on Bill's comments, these rules will continue to exist under the new mining law as well, until such time as these rules are revised or amended. So under the old law, these rules exist. Under the new law, until these rules are changed or revised, this is the regime that to some degree will also apply to companies going forward. So under MEMR Regulation 9, there are restrictions on structures which give rights equivalent to share ownership. So in other words, Regulation 9 is trying to stop nominee type relationships being crafted or structured where local shareholders, Indonesian participant shareholders or qualifying shareholders are somehow owning shares on behalf of foreign investors. The regulations try and stop that. As we all know, the investment law tries to stop that. And this is getting repeated again and again as a message. Again, under the regulations, current regulations, there are prohibitions on IEP, IEPK, COW, CCOW companies lending funds or otherwise funding the Indonesian participation. Now the wording is a little bit weird because it's not the restriction, it's not a restriction that says the foreign shareholders are prevented from lending money. It's a restriction on the actual operating companies lending those funds. But I think from a cautious, normal, conservative interpretation point of view, it's clear that what the guys are trying to get at is that there should not be loans of funds from shareholders or the IEPK companies, the IEP companies, CW companies to Indonesian participants to try and put into place nominee type structures. Likewise, the regulations and the rules say that there should be no grant of security. You shouldn't pledge the shares of the IEP, IEPK company, CW company, CCW company, so that you try and use that pledge to say, well, I cannot sell you my shares because I've secured them to a third party. The rules say, no, that doesn't work. You can't pledge those shares and then argue security. You can obviously pledge shares once divestment's taken place, but in the meantime, the guys are trying to stop arguments around security share pledges restricting the transferability of the Indonesian divestment shares. Next slide, please, slide 9. So that's, in a sense, a very quick run through what the old law said, and we'll pick up on some other aspects of what the old law, the old regime says. So what changed in the new law? Can we go to the next slide, please? So very briefly, what the new law says is that holders of IEP, IPK companies, the shares which are owned by foreign investors, so again, a reference to foreign investors without any reference to investors in the context of foreign investment. So in a very literal interpretation, a listed company structure, even where it's a PT Biasa company structure, would still be caught by this obligation. Must divest at least 51% of the shares in stages. That reference to in stages is actually quite important because under the old mining law, the reference was to, you've got to divest within 5 years of production or from 5 years of production. This new mining law doesn't say that. And that's probably one of the more key changes the new mining law is trying to do. In previous iterations, in previous drafts of the mining law, there was discussion about integrated mining companies getting longer divestment periods. So divestment beginning from 10 years of production rather than in the 6th year of production. So potentially, we have to wait to see, as Pat Bill says, till we see the implementing regulation. Potentially, there may be some additional flexibilities granted to integrated mining companies, where the smelter sits with the mining company. There may be some flexibility to defer divestment requirements for 10 years plus. If that does happen, that's good. It's merely foreshadowed in the current mining law, new mining law. So we'll have to wait to see what the position is on that. Again, the mining law says very clearly that if direct divestment cannot be carried out, then you can list through the stock exchange. That's quite a useful clarification too. It's not particularly new. It has sat there in some way or shape or form before, but this is a clear expression of that. The mining law says as well that in relation to divestment, the MEMR can coordinate central, provincial, regional authorities, BMN, BUMD, to determine divestment structure, whether it's going to be by way of share transfer or share issuance, to determine who takes up what, etc., and to determine shareholdings. That express statement, again, as Pat Bill was saying, is one of those things that has been sitting now in various implementing regulations, but it's now been lifted into the law to further empower the minister to try and create more streamlined, more efficient divestment processes. And if you have a look at Decree, for example, 84 of 2020, what that says is that in the context of provincial governments, regional governments trying to take equity in companies, mining companies, then it's the Minister of Finance who will coordinate the provincial regional government. So again, that's quite a useful clarification because again, the reality is, while it's potentially quite difficult dealing with SOEs, it's even more difficult sometimes dealing with BUMDs. So if that can be taken off and handled by somebody else, then that's a good thing. Next slide, please. We get asked this question quite often, and this is not a change in the law, this is just a clarification. What happens if you don't divest? Essentially, there's a waterfall of sanctions that apply. Written warning, fine, there's a typo in my slide, it should be temporary suspension or revocation of licenses. There's no change in that regime. We haven't seen the sanctions regime actually being applied, but we have seen the minister from time to time encourage mining companies that there is a divestment obligation to be satisfied. So this lurks in the background as a series of measures to be applied. Next slide, please. Next slide, Bob. So again, what changes in the context of the new regime? So we're seeing obviously divestment most actively towards SOEs. We're seeing Inalum being sort of the key player right now in the market. Bill's already talked about the idea of the IUPK area, and very often divestment, contract of work are issues that are linked together. And this idea of the maximum size of the IUPK being potentially expandable, no longer being limited by the old restrictions that Pat Bill mentioned, is potentially something quite useful. I take on board entirely Bill's comment that it's probably 90% aimed towards the CCOW companies, but there is potentially scope here as you're talking about divestment with SOEs to look to the SOE to help you in the discussions with the government to try and increase the size of your mined area to cover the entire development area that's being contemplated. Obviously easier in the context of coal, but even in the context of metals, there may be some scope for saying, well, actually, I don't just want to reserve my sweet spots. I'd like to preserve an area around my sweet spots because I think I can extend my sweet spots. Right now, most extension areas simply cover the sweet spot areas, but there's a concern that there might be stuff beyond that that could be mined. Again, Pat Bill's mentioned the context of the law that talks about CCOW companies being guaranteed extensions. That sounds better than it reads. The guarantee is subject to certain requirements, and those requirements, of course, bring in the idea of the minister reviewing whether or not you've satisfied those requirements, et cetera, et cetera. But potentially this idea of the guarantee might help in some of the amendment positions that have been reached with COW companies in the past. So in the past, we've seen COW companies accept quite good obligations in respect of the first extension, but slightly differently worded obligations in respect of second extensions or further extensions. And this guaranteed language may help to sort of put a bit more strength around the language or the entitlement to the extensions. And of course, that then feeds into valuation. It may help in valuation discussions to be able to point to the law to say, despite what my COW or CCOW says, actually the law gives me a pretty good argument that you should be valuing across 2 times 10 instead of across any initial terms. There's always an issue. There's an issue in the new mining law. There's an issue under the old regulations as to extensions of COWs versus new COWs that replace old COWs. That still stays there, but we tend to think that that most of the COWs that we've seen certainly are clearly intended to be new COWs, even if they're extensions of old rights. Next slide, please. Again, Pat Bill's touched upon this idea of extensions and increase in state revenue. And again, potentially, I agree with Bill, this is all about CCOWs by the looks of it, but potentially there is scope to say, look, as my COW goes into IPK license form, potentially you might be able to use with the SOE arguments to the minister to say, we can increase revenues not just by paying more tax, but we can increase revenues by increasing the area of mined operations. And although that most easily fits a coal mining story, there may be a possibility to make it fit a metal story as well. Again, there are prohibitions on, under the new law, there are prohibitions on securing IUPs, IUPKs, or ore. That doesn't really change very much, to be honest. As it stands right now, you can't really put security over IUPKs or IUPs. And as it stands right now, because the old mining law requires, it says that title only transfers once you've paid royalty. In effect, you can't actually secure reserves in the ground, and you can't actually secure stockpile. So in a sense, the new mining law doesn't add or change position very much, but it's a factor to bear in mind as you're talking to SOEs, talking about getting them in as shareholders, talking about how they're going to finance future development. It's a factor to bear in mind that some of these restrictions may come and bite you in the future as you look to raise financing. Next slide, please. Okay, so that's, in a sense, that's a very quick canter through what the old law says and a very quick canter through what the new law does. But there is some other issues around some of the current regulations, some of the more recent regulations, which may feed into the discussion around how divestment will take place. So can we go on to the next slide, please? I think the key thing that's happened in the past couple of months, I don't think necessarily coincident with the new law, but it just happens that it was in the past couple of months, is Decree 84 of 2020. And that sets out more chapter and verse on how you make an offer to the Indonesian participant, what the valuation, what the price mechanism will look like as you're discussing price with the Indonesian participant, etc. So very briefly, when you make an offer, you need to provide details, corporate details, list of shareholders, directors, and also of beneficial owners. So if you're a listed mining company, if you're a foreign investor with a listed mining company overseas, and you're now engaging in a divestment process, and you still haven't made an offer, as you go forward and make the offer, you're going to have to provide details not only of who's on your shareholder registers offshore, but potentially you're going to have to go beyond those shareholders and explain, for example, if you've got private equity shareholders, who are the beneficial owners behind those private equity shareholders. So it sounds like an innocuous requirement, but we've seen this concept of beneficial ownership and showing that as part of a transfers process. We've seen that requirement really becoming quite problematic in practice, particularly when you have institutional investors. That's detail. The main point, of course, is as you submit your offer, you've got to submit information about valuation assumptions, financial projections, investment costs and mining costs, depreciation and amortization, DCF factors, etc. You've also got to submit data on verified reserves and resources. And that sounds quite good. That seems to imply that actually under the decree, you will also put a value on resources as well as on proven reserves. The wrinkle sits that in addition to that information on verified reserves and resources, you've also got to provide approved feasibility studies as well as environmental approvals and financials. So the combination of language around resources and approved feasibility studies pretty much means that you're taking your resources and turning them into reserves. So as we read the decree, it seems to be suggesting in a very relatively soft way, softer than in previous versions of the regulations, that the guys are going to put a value on reserves, but that they're going to very severely try and discount resources. Next slide, please. Next slide, Bob. Great stuff. Okay. No, let's go back to 16. Yeah. Again, the regulation, I don't want to get too stuck into the detail. We're running over time, but the regulation talks about two bases of valuations, either DCF, discounted cash flow, or market data benchmarking. Now, it's not clear to me what market data benchmarking means. It seems to be a reference to looking at what other deals have happened in the market, to the extent that you can extrapolate from that. Or it might also be a reference to, if you're talking to listed companies with divestment obligations in their operating companies, have a look at the listed company shares and see if you can track back and reflect valuation. It's a relatively ambiguous concept, so I think the ministry, the SOEs, will be putting most weight on future discounted cash flows as the main way in which you're going to value divestment stakes going forward. Next slide, please. Obviously, some issues then arise in respect of Decree 84. The key one, in a sense, is a lot of CCWs already stipulate how you value the divestment shares. And what the ministry seems to be saying is, forget all of that. You're going to value the shares the way that we tell you, DCF, market comparators. So there's a bit of tension there, but the ministry position always is, we cannot negotiate outside the parameters that are set by the regulations. We cannot negotiate outside of our authority. So if the decree says this, even though we wrote it, we cannot negotiate something that's wider than that decree. So forget what's in your CCOW. The guys are saying, we don't really want to look at that. We've talked already about this idea is, are you going to value over the first extension or over extensions 1 and 2? Clearly, you should always be arguing for extensions 1 and 2, but clearly the ministry, the SOEs, the BMNs, whatever, are incentivized to try and find reasons why that second extension, even with the guaranteed language that's now been created by the mining law, why that second extension might always be a bit more questionable. The mining law helps in that discussion, so I think it's good from that point of view. Again, for a lot of companies, because of these requirements to build smelters, to process, to refine, there is a lot of value in existing infrastructure, even once the COW mining rights have expired. So again, one of the questions raised by the decree is, what value do you put on that existing infrastructure? Under the decree, the answer would seem to be potentially none, but that approach seems to me to be wrong. To the extent there's real residual value, you should be arguing that no matter what the extension periods are, beyond that, there's still a bunch of value to be taken from the SOE in those discussions with them about pricing, or in the discussions with the government about pricing. We already talked about this issue around reserves versus resources, and we'll wait to see how that pans out. But at this point, it seems to me that the decree is focusing primarily on reserves. Next slide, please. Other issues that we've seen in the context of divestment is really going back to what I was talking about before, what happens if we don't divest. In the context of trying to fit your contractual obligations side by side with the obligations set out by the law, what happens if you cannot divest? What happens if you can't find a buyer? Or what happens if COVID-20 happens and they're all affected by force majeure? What happens if you cannot divest within the relevant timelines? And in a sense, the answer is it depends what your COW or your CCOW says. But if the COW has language that says you will divest at this price and you cannot conclude the deal at that price, then the fact that you haven't divested, notwithstanding what the law says or what the COW says in terms of timing, the fact that you haven't divested at that price, I don't think you can be found to be in breach of the contract. The argument is we're allowed to sell at that price. If there's no buyer at that price, that's not our fault. We've satisfied our obligation to try and test the market. We've talked about the minister collapsing the waterfall and what happens there. We've talked about what happens if divestments don't occur in time. I think the other point to remember, this is key for people who don't have COWs, but have IUPs, is that you avoid a lot of these issues around divestment, obviously, if before the 6th year of production, you've identified a local shareholder with whom you're willing to enter into arrangements to take up those shares. And it's clear under the old regulations, by putting in a local shareholder at 51%, divestment is stopped. You no longer have to speak to the government, to the BMNs, the BMDs, etc., you've satisfied divestment. The divestment obligation is removed from you. So again, for those companies that have got IUPs, the answer always is start talking to local shareholders pretty quickly, or start putting into place local shareholder arrangements to avoid triggering the divestment requirements. And again, Bill may have different views, but our own view is, because even though you have that stepped divestment requirement, because all of those divestment obligations are subject to approval, you really want to be avoiding the situation where in year 7, year 8, year 9, you're still trying to divest more shares. Our own view is it's better to divest 51% before divestment kicks in, to try and mitigate the risk of the ministry saying, no, we're not going to approve your share transfer to the friendly local shareholder. You've got to offer to the government, the BMNs, the BMDs. That seems to be the worst case. So to avoid that, our own position is offer the 51% before year 6 of production. Next slide, please. I think probably better to make some time for questions if people have some. So let's go on to the next slide, please. Next slide. Next slide. So just very briefly to recap some of what we've been talking about. Divestment's a nasty process, and despite the good things that Pat Bill has rightly commented upon in the mining law, particularly around reducing some of the impact of provincial government, local government, around the protections that are afforded to big coal. The big issue around divestment still sits in the mining law. There is potentially this flexibility to postpone divestment for integrated operations, but that big issue of having to have a 51% local shareholder at some point still sits there, and that's unattractive from any sort of mining perspective. The reality is, in any sort of these divestment processes, either where you're forced to talk to local shareholders or local buyers or to the government, the reality is that by having these provisions written into the law, you're removing competitive tension. The guys know that they've got you against a wall. So that's one set of issues there. Again, we do see companies embarking in the divestment process and quite keen to sort of enter into sort of positive arrangements with Indonesian SOEs, with the government, with whoever. But that needs to be tempered with a degree of caution. Sometimes the expectation we feel is that people want to do a deal with the SOE because it's going to make life a bit easier when they deal with government authorities in the future. But the SOEs in this instance are very much the same as any other company. They have the same problems around licensing, around environmental compliance, around labor, around workforce, as foreign investors do. Maybe not quite so much, but they don't have the flexibility to waive all these problems or cure all these problems. Which is important as you start to discuss divestment. It's important to go in there with a real expectation as to how useful or creative that SOE relationship might be. Again, when you're dealing with the government, with the SOEs, whatever, financing is always a question. Obviously, right now, divestment is being funded by debt, and so that needs to be factored into some of the considerations about the process. Despite divestment being a mandatory requirement, you need to go through a bunch of approvals, so that approvals process needs to be factored into any structuring. And clearly, too, you need to be alert to the fact the guys. Coincidentally, regulations seem to change at the same time. Sometimes as divestment discussions are taking place. So you do need to be alert to the fact that the government is acting on quite a joined-up basis. It does seem to introduce regulations at the right time that help the government position in any negotiations on a divestment trajectory. Again, politics becomes crucial. So things like who controls the company, who's got the ability to tell the company what to do, have got to be very carefully managed, because the whole idea, of course, is that divestment is about Indonesianization and Indonesia taking control over its own resources. Other issues around future cash calls, future funding. Once you've got your Indonesian participant as a shareholder, no matter what your shareholders agreement might say, there's always this issue, well, what happens if the shareholder defaults on funding obligations? What happens if you cannot get cash calls paid, et cetera, et cetera? And those issues are there and are pregnant and have to be dealt with. Final set of issues around divestment really revolve around what is the status of these companies? Once you get taken over by a SOE, 51%, are you now an SOE subsidiary? Are you subject to SOE procurement requirements, et cetera, et cetera, et cetera? We take the view Probably not, because you're not the SOE, the subsidiary of the SOE. But at the same time, we do see a scenario in the future where potentially, who knows, in 5-10 years' time, the majority shareholder might decide to say, actually, no, you've now got to start following government procurement processes. You're not really a private company. On that, I've got nothing much more to say. Thank you all for your time, and obviously happy with Pat Bill to take any questions that you might have.
Thank you, Pa Norman Bissett, for the presentation. So I think we still have 25 minutes here, Pa Hadinoto, for the Q&A. And now we have a couple of questions here. First, I'd like to take the questions from Pa Ali Mardi. Pa Ali Mardi from Deloitte. He has 2 questions, but I'd like to the first question first. Yeah, first question is the draft law talking about the possibility of IUP transfer or as a deal. Do you envisage that this will need to be 100% interest transfer, or it could be certain percentage of undivided participating interest or PI, like in oil and gas, PSC, PI? So the question is addressed to both of you, and I'd let Pa Bill first to answer, and then followed by Pa Norman.
As I read the new mining law, and it's not that different from the old position, I think you can transfer the mining license in certain instances, but I don't think it really envisages that you can transfer participations in the mining license. There's a transferor and there's a transferee, but I really doubt that you can transfer a 50% interest in the license. Now, of course, you can manufacture a contractual arrangement around the mining license, whereby the holder of the license agrees to account to different parties for certain percentages of the revenue earned from the mining license, but that's not the same thing as selling or transferring a partial interest in the license itself. There's always a contractual arrangement that can be put around it, but to answer the question, I don't think you can transfer a percentage of the mining license as opposed to the mining license. That is 100% of the mining license. I don't think it really works. Okay?
Okay, thank you, Pa Bill. Pa Norman, do you have something to add?
Once again, Bill's genius eclipses mine. Agree entirely. I don't think you can transfer participating interest. We've seen these transfers in the past, and it's always been the transfer of the entire license rather than sort of creating rights over it. What the law does do, I think, is clarify that it's no longer subject to just transfers to affiliates. You can transfer to anybody. So it's potentially quite a nice way of structuring future deals, where if you're using an old dirty company with lots of liabilities, potentially there may be a way of actually transferring and creating a nice new clean structure, nice new clean vehicle, and making that a more attractive proposition.
Okay, thank you, Pa Norman. Pa Ali Mardi, I'll go back to you on your second question later on after I'll take the question from other participants. The next question is from Bu Aisyah Hanifati. She asked the question about the guaranteed conversion from CCAW to IUPK due to increased state revenue. Her question is, as we all know, the CCAW royalty is 13.5% from the sales. Will it be adjusted to the current royalty government tariff when the CCAW converted to become IUPK? Pak Bill?
Well, I think the answer is no one knows at this point in time. Obviously, the government is in a strong position to ask for some economic quid pro quo in terms of increased state revenue as a result of the issuance of continuation IUPKs. Accordingly, I think the government would be reluctant to see any reduction in the royalty. And I noted recently a number of media reports where perhaps not CCOW holders, but IUP holders in the coal space were saying that in these difficult economic times for the coal mining industry, the government should really reduce the production royalty for coal. And the government pushed back very strongly about this, saying, look, the government's fiscal position is extraordinarily tenuous at the moment. The last thing we can accept is a fall off in revenue from the coal mining sector. So don't even think about asking for any reduction in royalties. And I would imagine the government would be even more strongly of that view in the case of CCOW holders, particularly because I think the government rightly feels it's done a whole lot to help the CCOW holders, and it really would be pushing the envelope just a bit too far for the CCOW holders to say, well, thanks for that, government. Now we'd like a reduction in the royalty as well. It's meant to be an increase in state revenue, not a reduction in state revenue.
Okay, thank you, Pak Bill. I'd like to take the second question from Pak Ali Mardi. The question is, under the draft law, can an IUP company pledge its shares to raise financing? I think I'd address to Pak Norman.
Not in respect of divestment shares. So you could theoretically, I think, theoretically pledge up to 49% of your shares, but not 51%. You can post divestment, you can pledge shares without restriction. So if you're going to divest shares, one of the discussions we're having is we want you, if you're doing joint financing, we want you to support us to pledge your shares for any third-party lenders. But there is that very clear restriction on securing divestment shares. Now that doesn't mean that you cannot pledge shares, I think, from day one. Divestment obligation kicks in from the beginning of the 6th year of commercial production. So theoretically, beyond, at least through to the development phase, you should be able to pledge shares, but then you have to unpledge to be able to transfer them to the Indonesian participant.
Okay, thank you, Pak Norman. Pak Bill, would you like something to add?
No, I agree with Norman on that score. I think prior to the 5th year, the end of the 5th year of commercial production, there's probably no restriction on pledging the shares. Okay.
All right. Thank you, Pak Norman and Pak Bill, for your response. And the next question from Pak Ian Wolf. If a IUP sells 51% to local business party, is there anything in the law to stop that local party to later sell all or part of those shares to another party, or not to another foreign party? Pak Bill?
Well, this is probably a little bit unclear, but I certainly don't think that's the intention of the legislation. The intention is that certainly while the company remains unlisted, well, so long as it's not listed on the Indonesian Stock Exchange, as of the end of the 5th year of commercial production, it's meant to start divesting its shares so that at the end of the 10th year, not less than 51% is owned by local parties. If the local parties were then to subsequently transfer the shares to a foreign party, it seems to me that that would negate the whole divestiture exercise. Now, can I point to anywhere specifically in the mining law that says that's not possible? No, I can't. But what you have to remember is that any transfer of shares in an IUP holder now requires prior approval of the minister. So I just cannot believe that the minister would approve a transfer of divested shares currently held by a local party to another foreign party, thereby undermining the divestiture intention. So I think it's that requirement for ministerial approval of all share transfers in IUP holders that is the real bar to that type of arrangement that Ian Wolf has mooted. Okay, but I can't point to anything in the law that says no, you can't, but I think as a practical matter, the minister wouldn't allow it.
Okay, thank you, Pak Bill. Pak Norman, you like something to add? What?
No, I think Bill's absolutely right. There's nothing in the law per se. Obviously, it's also to MMR approval, so that's going to be obstacle number one. obstacle number 2 is that there are reams and reams and reams of rules and regulations for government SOEs as to how they divest, transfer assets, whatever else. So very quickly you bump against restrictions just under the general body of rules and laws that apply to the government in terms of divesting, transferring, selling, etc. Once you've got something as a government, it's actually quite sticky and difficult to get rid of it. We saw similar sort of provisions in respect of the oil and gas sector, where Petromindo had these sort of preferential rights. And over time, the rules caught up, and it was written into the rules that Petromindo, once it uses its preferential rights to acquire, will not transfer. So practically, you can't do it. From an SOE government point of view, it's actually not that easy to do. And likely the rules and regulations will catch up over time to stop it from happening.
Okay, thank you, Pak Norman and Pak Bill. Before I take a question from Pak Andi Karamoy, I'd like to add something that the question from Bu Aisyah, yeah. Pak Bill has mentioned about there will be no guarantee that the government will decrease the state revenue from the company that converted CCOW holder converted to become IUPK. Even the rate will increase, the royalty rate. I saw a draft of the government regulations on the tax statement for coal companies. Yeah, the draft was discussed, I think, in the late 2018, and I suspect that the royalty tariff for ex-CCOW, yeah, will be higher, yeah, probably, because at the end the government take should be higher. That's the part of quid pro quo, as mentioned by Pak Bill earlier. Okay, the next question from Pak Andi Karamoy, yeah, to all panelists. Yeah. If a company enter into a new downstream or downstream business or hilirisasi, will there be a conflict later between contract terms between the mining and the downstream business? Say the company is building a DME business with 15-year terms, while mining company license will expire within 10 years. How to deal with these situations? Will the PMA company can get a further 5 years extension above the law? Thanks, Pak Norman first. Yeah.
Wow, I was hoping Bill would go first on that one.
Very pleased for you to take that one, Norman, I am.
Yeah.
Makasih banyak, Pak Andi. Briefly, no, I don't think it is. I think as a starting off point, the COW company has got to, just because you've entered into longer term arrangements, I don't think is sufficient to say that the COW company can somehow try to use those longer term arrangements to argue for additional extensions beyond the law through the IEPK, et cetera, et cetera, et cetera. So I think to the extent you're trying to create bankable structures with your offtake arrangements, you've got to create those bankable structures anticipating 1 times 10 or 2 times. But you can't go beyond that. Again, it's not entirely clear what happens at the end of 2 times 10, but I don't think it's automatic, for example, that that somehow, let's say, Inalum takes over 100% of the shares of the entity. It goes from 51 to 100. I don't think that's necessarily automatic. There could be theoretically a situation where actually the whole thing just reverts back to the government, and then the government reissues an IEPK or whatever the concession is going to be after 20 years to Inalum. But there's not necessarily continuity in the company. So those contractual arrangements that you might have entered into for beyond the life of mine may in practice not survive beyond the life of mine.
Okay, thank you, Pak Norman. Now, Pak Bill, do you have something to add?
I think I would agree fundamentally with what Norman has had to say. This is always a problem. In the standard contractual arrangement, the IUP holder or the IUPK holder would always be requested to warrant that it has all the licenses and approvals needed to operate the business for the life of the contract. That's not a representation and warranty it could clearly give or should give if it's only got a contract if it's only got a license that's good for 10 years, but it wants to enter into a contract which requires it to have that license for 15 years. So look, that would always be a problem from a financing perspective, from a contracting perspective. And I would absolutely agree that with Norman's statement that merely because you've been so bold as to enter into a contract for 15 years when you've only got a license for 10 years, that provides no grounds whatsoever for going back to the government and saying, well, look how bold I've been. Now you please need to increase my license by another 5 years. I don't see any basis in the law for doing that. And I'm as confident as I can be that the government would knock you back.
Okay, thank you, Pak Bill. Pak Adianto and Bu Desi, if there is no other questions in the chatting room, I think this question from anonymous attendee will be the last questions. The question addressed to both of you, Pak Bill and Pak Norman. The question is, in practice, what type of securities do the mining companies use to get financing if mining licenses cannot be put as security? And the same also applies with the community and less than 50% shares starting from the 6th year. Pak Bill first, and then followed by Pak Norman.
Well, what financiers would normally look for in security terms is some control over the proceeds from the sale of coal or other ore or minerals generated by the license holder. So the traditional approach is to arrange for these proceeds to be deposited into a bank account in, say, Singapore, and for the financier to take security over the bank account in Singapore so that it effectively has control over the revenue stream from the use of the license. That's probably the most effective form of security that there is available. You can, of course, also do things like fiduciary charges over the equipment used on the mining concession. But fiduciary charges over mining equipment are extraordinarily difficult to enforce in practice and have only become more difficult as a result of a Supreme Court decision earlier this year, which suggests that the holder of the security cannot immediately proceed to enforce its security and sell the machinery unless it first gets a decision from the courts in its favor. So I would suggest that the standard preference is for security over the revenue stream generated from the license, require the license holder to have the revenue stream paid into a bank account in Singapore and take security over the Singapore bank account. The next best, but far less attractive, would be to try and take fiduciary securities over tangible assets used in connection with the mining concession. The third would probably be to seek a guarantee from a parent company, something of that nature. But generally, control of the revenue stream from the sale of the mineral product is the way to go.
Okay, thank you, Pak Bill. Now, Pak Norman.
That's been a great answer by Bill. There's nothing much more to add to that. It's receivables, whether it's cash, sales receipts, insurance proceeds, and to the extent that you can, within the confines of the mining law, it's share pledges, et cetera, et cetera. You always want to try to avoid the guarantee, of course, but if you have to do it, you have to do it. But it's primarily against receivables.
Okay, thank you, Pak Norman. I think there is no other questions from the audience, but I'd like to ask you a last question, maybe it's my personal question, that as a closing remark from you guys. We're talking about, I mentioned earlier in my opening remarks about the implementing regulation, draft of government regulation. What is your comment and expectation, Pak Norman, and followed by Pak Bill?
Listen, the first time the mining law came out in 2009 was one of the first times, I think, Indonesia, Bill can probably correct me if I'm wrong, but it was one of the first times Indonesia actually set out a timeline for implementing regulations. And fair enough, the guys did come out with GR23, whatever it was, within the 12-month period. So to the extent the mining law says the same thing this time around, then I suspect there will be at least 1 or 2 key bits of implementing regulation to follow on pretty quickly. And then that's, as you say, that's where the fun begins, because the devil is in the detail. And if things improve dramatically, then we may see a raft of implementing regulations that try and take back some of what's been written by the mining law.
Thank you, Pak Norman. Pak Bill, what is your take?
Yes, let me just add to Norman's comments, which I fully agree with and endorse. My concern, Sinadia, is that the government may be unrealistic in its expectations as to what the new mining law will do in terms of spurring increased or renewed interest amongst investors in the mining industry. And I say that because owing to the uncertainty that exists until we have the implementing regulations, I think what the government is going to find is that many investors, if not all investors, are going to say, well, look, there are lots of interesting things in this mining law, new mining law. If it all pans out as we hope, that'll be great, and we'd be very happy to invest more, but we're not doing anything, thank you very much, until we see those implementing regulations. You know, there are too many examples of implementing regulations coming out which seem to be at great divergence from what the law originally provided. And I think it's very much a case of once bitten, twice shy amongst foreign investors. Show us the implementing regulations, and then we'll make a decision about investing. So my concern is the government may have unrealistic hopes as to how quickly the new mining law will spur greater interest in the local industry. My guess is until we have all the implementing regulations, people are going to be interested, but they're not going to put their money into new projects or expanding existing projects.
Okay, thank you, Pak Bill. Sorry, Bu Desi, one more quick question to both of you. I just found out that the new law has a provision that the government provide guarantee on the permit and the guarantee on the transferring of permit. The word guarantee for me, or jaminan, is I never seen in the mining regulations before. So how strong are this provision to assure foreign investor that Indonesia means business? Pak Bill, very quick, and then followed by Pak Norman.
Guarantee is a big word, which has very different meanings for lawyers than it does for business people and government people. I think you should read guarantee as meaning the government will do its best to ensure that you get the licenses and land. But I think it would be unrealistic to assume that it's absolute obligation that you can hold the government to.
Thank you, Pak Bill. Pak Norman.
I suspect that guaranteed language part will be as strong as the government's commitments or the government's promises under COWs that COW is the only license you need and that you can do whatever you want. So I think it's primarily about optics as opposed to something that's going to be all that real. Okay, thank you. Pak Bill Sullivan from Christian Theo and Partners. Pak Norman Bissett from Hadiputranto, Hadinoto and Partner. Thank you for your participate in the events. Thank you.
A pleasure.
Audiences, and then
thanks to you all.
Yeah,
and thanks for your attendance. Thank you.
Keep safe. Yeah, thank you, Pak. Bu Desi and Pak Adi.
Yes.
Thank you, Pak Hendra. Okay, everyone, we are now come to the end of this webinar. Thank you very much for your participations and support to CoalAsia and Petromindo events. So the recorded version of this webinar is ready at the Dropbox link we already share you at the chat column. So if you would like to watch the recorded version, you can find it at the link. So Dropbox link, yeah, we already given at the chat column, and also the material of presentations. Okay, thank you very much to all speakers. Bapak Bill Sullivan directly from Australia, ya Pak Bill?
Yes, Desi, thank you for your moderation.
Thank you very much, Pak Bill Sullivan from Christian Theo and Partners. Mr. Norman Bissett, thank you very much for your time.
Thanks to you and to Petromindo.
Thank you for your support, and also Pak Hendra. Sehat terus ya Pak, tetap semangat.
Thanks. Catch up. Bye-bye.
Okay,
later.
don't miss our next webinar event next Wednesday at June 17. We have will the new mining law boost smelter development? Yeah,
Wow,
also with Pak
very
Hendra.
interesting. Thank you.
Yeah, thank you
Thank
very much, and
Okay.
we hope
Thank you
all
very
of you
much.
can stay safe, yeah, adapting with the new normal condition, and see you later. Goodbye.
Bye.
See you later. Bye-bye.
Bye.
Pak Norman,
Pak Norman.
Ciao.
Pak Bill, Bu Desi, Pak Adi, thank you.
Thank you,
Oke,
Pak.
Pak.
Bye.
Terima kasih.
Thank you ya. Makasih ya. Pamit ya, Pak.
Oke,
See you.
Pak.
Sip. See you.